This is video lecture 3 for the makeup for class on Monday, September 12th in evidence. The next rule that we're going to cover here is Rule 404B. Okay, 404B covers the prohibited and permitted use of evidence of past crimes, wrongs, and other acts. Okay, so 404B1 here on the slide sets forth that basic rule that evidence of a crime, wrong, or any other past act is not admissible if it's being offered to prove character, to show that a person acted in accordance with that character on an occasion at issue in the case, right? Because that would be inadmissible, character propensity evidence. But 404B2 tells us that evidence of past acts that would otherwise be considered inadmissible character evidence might be admissible if, and that's a very big if the evidence is offered for another purpose. So under this rule, 404B and the comparable California Code 1101B, evidence of other crimes, wrongs, or acts might be admissible if they're relevant to prove some fact other than character. Okay, now, in this situation, there could be two possible purposes for the evidence, right? One, the impermissible purpose of proving character to show propensity, but then there's this other possible alternative purpose. And in this situation of a permissible 404B reason, the evidence is being offered as substantive evidence of guilt in a criminal case, for example, or substantive evidence of some relevant provable fact in a civil case. Okay, so it's not being used as character to show propensity, not as circumstantial evidence. Okay, so in this area, you won't be surprised to hear that it's very common for cases with similar facts to be decided by judges in different ways in different courts because of the tremendous judicial discretion in this area. So it makes this a particularly slippery area if you're trying to discern any sort of pattern in how these arguments will be decided. So when you see a 404B issue on an exam essay, you're almost certainly going to want to look at both sides. In fact, I would say certainly want to look at both sides because there probably won't be a definite right answer. Okay, so here's just Rule 404B, and I have some highlights and some comments here in red typeface. So the first reminder is that even though part of Rule B2, 404B2, only applies to criminal cases, the rule as a whole applies to both civil and criminal cases. Okay, so the rule as a whole applies to both criminal and civil cases, notwithstanding the part below that only applies to criminal cases. All right, next. The use here in 404B2 of the phrase may be admissible reminds us that this kind of evidence, 404B evidence, can be kept out by a judge if the probative value is substantially outweighed by one of the 403 dangers like undue prejudice. Okay? Also, as I'm sure you probably anticipated, if this kind of evidence is admitted, there is going to be a jury instruction telling the jury that it is supposed to use the evidence only for the designated permissible purpose under the rule and not as general character evidence. And then we see down here in 404B2 that in a criminal case only, if the defendant's counsel requests notice, a prosecutor has to provide notice of her intention to use any other crimes or past acts evidence in this way. The prosecutor has to disclose that that is going to be attempted, what the nature of it is, and that has to be done before trial, unless, of course, there's a good excuse, which is a hard one to sort of swallow. Like, what would be a good excuse for that? So anyway, one might question here why a criminal defendant should have to request this information. After all, this kind of evidence has such a high potential for prejudice in the first place. Maybe it should be an automatic requirement in criminal cases, but as it stands, criminal defense lawyers are going to be very wise to always have a request like this be a part of their pretrial procedures, because you don't want to be surprised by a prosecutor trying to bring in otherwise impermissible character evidence under this rule and not have any notice of it. Okay, so the examples that are given here in the text of Rule 404B are the typical possible purposes, okay? But the use of the phrase such as in the rule, you see in 404B2, it says, this evidence may be admissible for another purpose such as, okay, and then it goes on to list those possibilities. But the fact that they use the phrase such as shows us that it's not an exclusive list, okay? So in theory, there could be another possible purpose that a judge might find permissible. But the ones that are listed here are evidence to prove motive, to show opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. And we're going to talk about all of those. Okay, hopefully you could hear that that whistle on the video, since that was one of my inserted special sounds for one of my mnemonics. My mnemonic here for 404B, okay, SS Kypomia. Now, SS Kypomia includes all the ones that are listed in the rule and two additional ones that come from case law. And those two additional ones are denoted by the two letter S's in the steamship name, SS Kypomia. Kypomia itself is a pretty common mnemonic, actually, for the letters in the rule itself. But I thought adding the S and the S was important to cover these extra two possible purposes, and then it also kind of hopefully makes it more memorable if it's plastered on the side of this ship, so you'll remember the SS Kypomia. All right, so here are all the letters in the mnemonic laid out with the type of evidence each one stands for, and we're going to talk about all of these. So S stands for story completion. The other S stands for signature crime or modus operandi. K is for knowledge, I for intent, P and P for plan and preparation, O for opportunity, M for motive, I for identity, and A for absence of mistake or accident. Okay, absence of mistake or accident. All right, so in your assigned reading, you had the McCormick excerpt about this kind of evidence. And after reading that, I think you probably all understand why Rule 404B generates such a huge amount of confusion and litigation and argument, especially in criminal cases. And like I said before, it leads to often really divergent results. In fact, the data out there are pretty clear that Rule 404B is actually the subject of more appeals than any other rule of evidence. More appeals than any other rule. Okay, and make sure you note on the upper right side of this slide that I've reminded you Rule 403 is always going to be in the mix here, since this kind of evidence can be kept out if the probative value is substantially outweighed by one of the 403 dangers like undue prejudice. Also, if this kind of evidence is admitted, again, there is going to be a jury instruction telling the jury that it is supposed to use the evidence only for the designated permissible purpose under the rule, and specifically not to use it as general character evidence. So that McCormick piece in the book presents some really good examples from case law. I think they're very helpful. I'm going to go over each one of those individually. I'm also going to mention a few other examples because I think examples really help a lot here. Just hearing about some real cases on the books dealing with each one of these things. But, you know, one thing you have to keep in mind here is that when you have a hypothetical situation, there's almost always going to be more than one possibility to try to get evidence in under this Rule 404B. And as you're going to see, these categories kind of overlap each other sometimes. So it's certainly an area that allows for some creativity. And you also just have to keep in mind that the same piece of evidence might be offered under more than one of these. Okay, so the first letter S is this idea of the complete story principle. The idea is it helps to place the crime in a criminal case and the situation in a civil case in the context of nearby events that are happening at or near the same time. Okay, so the book points out that this is supposed to be a very, very narrow situation. It should only be used when it's absolutely necessary to explain the charged crime in a coherent way or to explain whatever the civil issue that somehow might be relevant in a coherent way. So the book talks about one example of the admission of taped conversations with undercover agents with a putative drug dealer about a drug sale and allowed those taped conversations to come in, even though the conversations mentioned other drug sales aside from the one that were being tried in the current case. Okay, so if you think about that case, I'm sure this presumably happened in a case where the tape that they were talking about here could not be edited to take out any reference to the other sales without making it completely incomprehensible, because otherwise that would be, of course, an alternative is kind of redacting a tape like that. One other case mentioned in the book is where the court admitted testimony about drug sales to more than one person that took place at the same time in the same place. So this was an undercover officer testifying about standing in line to buy drugs from a dealer and describing the other sales that happened prior to the one that happened with him that was the charged crime. Let's see. There was another one described in the book where stolen guns were found on a defendant, and evidence there was admitted on 2 burglaries of guns on the same night. I think in the main case there, the defendant was actually being charged with burglary of a sporting goods store to steal guns. And guns from the store were found on him and admitted into evidence, obviously. But the court also admitted evidence that other guns that were in his possession had been reported stolen that same night from a family friend's house. So there, it was a completely, different crime, but the prosecutor there convinced the judge that putting in the evidence about this other alleged theft of guns that happened on the same night somehow belonged in the context of the charged crime. Okay, I've added a couple of other examples from case law on the slide here. I have on the slide the 11th Circuit Atkins versus Singletary case. In this case, a court admitted the defendant's confession to sexual battery of a victim in a homicide case. So the victim in this case was killed by someone. And the court here, but the defendant here wasn't being charged with any sexual assault in the case, just being charged with homicide. And so it wasn't a charged crime, but the court there admitted the fact that the defendant confessed to sexually battering the victim, while claiming that he didn't also kill the victim. So admission of a separate crime was admitted there under this complete the story principle. And then the last case on the slide here is a Mississippi case, Hearns, in which the court there admitted evidence about a prison inmate's sexual assaults on other prison inmates. And the court admitted this under the theory that it was necessary to show this inmate's domination of all the other inmates in the prison in a case where this inmate was actually being charged with murdering another inmate. And I'm thinking probably the prosecutor argued here, this has to come in because I need to explain why none of the other inmates were willing to testify against this guy. If he really murdered this other inmate in the prison, there would have had to have been at least one witness. Why wasn't anyone testifying against him? And this was the prosecutor saying that this evidence had to come in to explain why people might have been too intimidated to testify. Okay, so that's the idea of story completion. Okay, the next letter S stands for signature crime. Evidence used to prove other crimes or acts by the defendant that are so similar in method that they can be earmarked as the mark of this particular defendant. Now, this is one of the things that, in fact, isn't spelled out in the rule itself, as it's not listed in the rule. It's also sometimes referred to as the modus operandi evidence. Now, I've already used an example of this in class. Remember our example of the nursing home burglar that came in through the door, only stole underwear and left a rose and a Batman mask on the bed. Okay, so again, it's supposed to be something that's very unusual and distinctive. Now, some people kind of lump this one in with the I for identity that is actually listed in the rule. So certainly use of evidence here under this idea, under this signature crime type purpose, is really just a way of showing identity of the perpetrator, right? I mean, you show identity of the perpetrator by showing, look, this crime was committed in this very unusual, distinctive way, and here's the evidence that this person did this in the past. So identity is one of the listed exceptions in the rule. Okay, but distinctive features of a crime and the fact that other acts or crimes with those features were also committed by the defendant can also be relevant to other factors like intent or lack of mistake or accident. Okay, intent or lack of mistake or accident can also be proven using this idea. And again, remember that it should be something that is more than just a superficial similarity, and it should be something that's very unusual and particularly distinctive. So the classic case cited for this purpose is that Brides of the Bath case that's described in the book. So we had there a man who was already married, and he married another woman, even though he was already married, who had just inherited a big trust fund. He married her under an assumed name. Shortly thereafter, the new wife is found drowned in the bathtub. Now, there wasn't a lot of direct evidence here against the husband. There was no proof he was with her at the time of the drowning. In fact, there was also no sign of a struggle, and the wife had been seen by a doctor for a seizure disorder that in fact could have caused the drowning. So maybe reasonable doubt there, but It turned out that after that wife died, he also pretended to marry two other women who made out wills leaving him all their money. And they too ended up dead, drowned in the bathtub. So actually, in this Brides of the Bath case that's on the slide, it was in the trial for the first murder that the other two later dead wives' evidence was admitted, and he was found guilty there and hanged. You also saw the other case in the book, the Woods case, where a woman was accused of suffocating her 8-month-old foster son, and their evidence was admitted that 9 other children in her care had suffered cyanotic episodes of turning blue due to lack of oxygen while in her care, and 7 of those had also died. So that evidence was admitted there. I have on the slide 2 bank robbery scenarios. One is the Myers case from your book, where the other crimes evidence was not admitted because it was found not to be unusual enough. Okay, and one, a made-up example, where I think the signature crime evidence would be admitted in a bank robbery case, in which the robber here in my imagined case wore a Richard Nixon mask and did all these other unusual things. So looking at Myers, the court there said, look, an early afternoon robbery of an outlying bank situated on a highway by revolver-armed robbers wearing gloves and stocking masks and carrying a bag for the loot is not such an unusual crime, right? So the evidence there of these other robberies not admitted here against Myers by the Fifth Circuit said should not have been admitted. And in my hypothetical case, I've got a perpetrator going into a bank wearing a Richard Nixon mask, carrying an antique pistol, speaking in a German accent, saying, "Hand over the money and I'll forgive you all your sins." That's a terrible German accent. And then skipping out of the bank singing "God Bless America." So now evidence of prior identical crimes there would probably be admitted. Okay, this is all not to say that some courts in the country actually haven't admitted fairly garden variety evidence and still called it modus operandi evidence. For example, there was an Arizona case where the only similarities between the crimes were that they all involved robberies of similar convenience stores. So that one was a huge stretch. There's another court admitted past a bank robbery evidence in a bank robbery case where the most distinctive thing the court cited was that in both robberies the robbers entered the bank holding a knife vertically. So I will say that courts have been all over the map here, but a court using this purpose properly is going to look for something that's quite distinctive. Now, in the reading for today, you read the Carrillo case, and in that case, the trial court there was reversed for admitting prior sales of drugs in balloons held in the seller's mouth. The trial court had admitted those under this modus operandi scenario, but the appellate court said that this practice of holding drugs in someone's mouth in balloons, in the seller's mouth in balloons, was not distinctive or unusual enough, and the Fifth Circuit reversed there. But I do have on the slide a similar Fifth Circuit case from the exact same year, actually, in which the appellate court there upheld modus operandi signature crime evidence that the defendant there sold his drugs in pink balloons. So the Fifth Circuit said, look, just selling drugs in balloons held in the seller's mouth, not distinctive enough to be modus operandi signature crime evidence. But the Fifth Circuit said, oh, if the defendant only uses pink balloons for his drugs, that was found to be distinctive enough for admission. Okay, and the last thing I have on this slide is the concept of the doctrine of chances. which is really sort of a variation on this signature crime theory that applies especially to cases like the brides in the bath case or the cyanotic children case, and I think also overlaps with the other possible purpose of showing lack of mistake or accident. So this doctrine basically requires looking into, well, how likely is it that a defendant would possibly be innocently involved in whatever similar acts are offered as evidence? So basically, the idea is a freak occurrence might happen once, but if it happens more than once or again and again, the chances of it being an accident or mistake really diminishes. Okay, so we finished S and S, so now let's go through, start going through the Kipomia permissible purposes for specific act evidence, starting with the letter K for knowledge. So this is also sometimes referred to as the guilty knowledge purpose. You are going to read for Wednesday the Huddleston case. As you're going to see, in Huddleston, the defendant there was charged with trying to sell stolen property, and the court there admitted evidence that he had sold other stolen goods in the past that he had in fact gotten from the same source. Okay, and the permissible purpose under which this was admitted was to show his knowledge that the items were stolen, because in fact his defense in the case at hand, as you're going to see, was that, oh, he just had no idea that those items that he was trying to sell were stolen. Okay, so Huddleston is a great example for the letter K for knowledge. Now, the other one I have on this slide is a good one for knowledge. If we had a defendant in an IRS tax fraud case, let's say the defendant deducted his roommate as a dependent, and that defendant was claiming, oh, I had a good faith belief that that was legal, then evidence that she was warned by the IRS in the past not to deduct random people like roommates, obviously that would be admissible, okay? Evidence that she had been warned in the past. Another classic one on knowledge is a defendant who's claiming that he didn't know a particular substance in his possession was an illegal drug. Didn't know the substance was an illegal drug. So in those cases, a prosecutor might get evidence about past drug use or past drug crimes admitted to show guilty knowledge, right? To show, oh, you actually do know what marijuana looks and smells like. So the fact that you're claiming you thought it was some other herb is not that plausible. I also have on this slide a tort case example in Ray Korean Airlines disaster, a case from 1991. Here, Korean Air was sued for flying over Soviet airspace when the Soviets shot down one of their commercial airliners. So Korean Air here claimed not to know that flying over Soviet airspace was a bad idea. They just said, hey, we had no idea. We shouldn't do this. And in this case, the court admitted evidence about the negative consequences suffered by other airlines when they had veered into Soviet airspace as evidence that Korean Air, in fact, did know or certainly should have known. So that fell under the knowledge purpose as well. Okay, I'm going to end this video here and pick up in video number 4 with the next letter, which will be I.